There's a federal court decision from earlier this year that has been generating a lot of conversation in legal circles and a lot of confusion. If you've seen headlines like "Court rules AI chats are not privileged" or "Your AI conversations can be used against you," I want to give you the accurate version of what actually happened and what it actually means for you. The case is called US v. Heppner. A criminal defendant used a free version of an AI tool to generate documents analyzing his own legal situation, then sent those documents to his attorneys. The government wanted those documents. The court said the government could have them. The AI communications were not protected by attorney-client privilege. Why? Three reasons. First, the AI is not a lawyer, so talking to it is not the same as talking to your attorney. Second, and this is the part that gets lost in the headlines, the defendant used the free consumer version of the tool, and the terms of service for that free version explicitly allow the company to access and review conversations. There was no reasonable expectation of confidentiality. Third, the defendant did this on his own, without his attorneys asking him to or directing him to, so it was not made for the purpose of getting legal advice. The free version matters. That's not a small detail buried in the opinion. The court's analysis was specifically tied to the terms of service for the free consumer product. A paid enterprise tool with a data protection agreement and explicit confidentiality terms is a different factual situation that the court did not address. So what does this mean for you practically? If you're a person who sometimes runs legal problems through a free AI chatbot or even a paid one before calling your lawyer, stop doing that for anything you want protected. I'm not kidding. Stop it. Heppner confirms that those conversations are most likely not privileged and can be subpoenaed. The AI is not your lawyer. I don't care how experienced and knowledgeable it sounds, it is not a lawyer, and talking to it about your legal situation on a free platform is not the same as talking to counsel, and it does not get the legal protections that communications with your attorney do. This does not mean AI tools are dangerous to use in general. It means you should understand the difference between using AI to draft an email, research a business question, or help with your marketing, which are all usually fine, and using AI as a substitute for actually talking to your attorney about sensitive legal matters. Those are different things, and Heppner makes the difference consequential. What does that recent court case Heppner mean about your attorney using AI? Heppner was specifically about a client using AI on their own. It was not a ruling about attorneys using AI in their legal work. That question is still developing, and there's ongoing guidance from bar associations about what attorneys need to do before using AI tools with client information. The short version is that attorneys are being advised to use enterprise-level tools with proper data protection terms, to use placeholder information rather than client-identifying details when possible, and to verify everything an AI tool generates before relying on it. If you're working with an attorney and wondering whether they're using AI tools, you're allowed to ask. A competent attorney should be able to tell you what tools they use, what data protections are in place, and how they verify AI-generated work before it goes in your file. Here's the AI and privacy issue that's not getting enough attention. AI meeting transcription tools. Tools like Otter AI and the built-in AI assistant in the Zoom paid versions are increasingly common. They automatically record, transcribe, and summarize meetings. Now, for routine business meetings, they can be very useful. For meetings where you're discussing anything sensitive, including conversations with your attorney, they're a significant problem. Usually, when an AI note taker is running in a meeting, a third-party service is receiving and storing the conversation. That's true even if you technically have control over the recording. The transcript and summary that get generated exist as documents outside your protected environment. They could be subpoenaed, they could be hacked, they could be shared accidentally. Now, if you're meeting with your attorney and either of you has an AI note taker running, the privilege analysis gets complicated in ways that could be very inconvenient. The New York City Bar issued a formal opinion at the end of 2025 specifically on this issue, concluding that, for starters, attorneys need client consent before any AI recording tool runs in a client meeting, regardless of what the local wiretap law technically requires. My practical advice is, if you're in a meeting with your attorney about anything sensitive, ask whether any AI recording or transcription tool is running. You're entitled to know. And if you're running one from your end, turn it off. Now let's look at the bigger picture. AI tools are not inherently dangerous to your legal protection. The risks come from specific avoidable mistakes, using free consumer platforms for legally sensitive communications, not understanding what terms you're agreeing to when you use a tool, and treating AI as a substitute for actual legal counsel rather than a supplement to it. If you want the full attorney-level analysis of Heppner, including where most of the published commentary is getting the scope of the ruling wrong and the complete picture of attorney AI ethics obligations, that's in this week's companion podcast episode. You can find it at Spellbinding IP on your favorite podcast platform, and I'll put a link in the description. And if you want the full breakdown of how AI affects your copyright, trademark, and patent protection as a business owner and creator, that is last week's episode, also linked below. Avoid the legal horrors and keep rocking your IP. If you're interested in working with an IP lawyer who understands these issues, book a consultation at kingpatentlaw.com. This information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney. This episode may contain attorney advertising material. Law firm address and other contact information is in the show notes and bio and available at kingpatentlaw.com.